In this episode, we talk to our friend, Phillip Russell, about the Supreme Court decision that overturned Chevron Deference. And we got to get into what that is, of course, if you haven't heard of it. I thought it was an important topic to talk about as it relates to how government agencies relying on quote-unquote experts to establish policy that in turn translates into, or could translate into, standards, procedures, laws, things that we as businesses have to follow. Now, on its face, most safety professionals probably didn't think of this. I know I didn't until I started reading and looking into it. And so that's why we talked to Phillip Russell about how this could extend into the Department of Labor, for example, or OSHA, or the EPA in the case that we discuss. But I think it's very interesting. I kind of got a little nerdy with it, which is normal for me, but I thought it was a good topic. I want to know what you think. If you want to see the full video of this interview, then head on over to the SafetyPro Podcast Community site, become a member there. It's free to join. You can watch all the video interviews. But if you want to participate and drop your comments and post your own content, then you do have to become a premium member. And so, again, head on over to the SafetyPro Podcast Community site. The link is in the show notes. Otherwise, please enjoy this conversation with Phillip Russell about the Supreme Court decision to overturn the Chevron Deference. Before we get into today's topic, I have one question for you. Are you still painting your floors for 5S markings, things like that? Don't do that. Head over to mightylinetape.com/podcast, a great partner in safety. They've been with us from the beginning. They have some really good products that are going to get you out of a whole lot of time, material, and maintenance and upkeep. Their floor marking tape is second to none. It takes up easily, doesn't leave a sticky residue. They've got floor tape with beveled edges for forklift traffic, carts, things like that. So it really holds up well to that kind of traffic in your facility. They also can do custom floor signs. If you have a particular logo or a message, they can make that happen. Get a free sample and try it for yourself. Again, head over to mightylinetape.com/podcast. Tell them that we sent you. You will get a free sample to try out in your facility today. Again, mightylinetape.com/podcast. Do you want to ensure you're compliant with OSHA standards? Do you wish there was a way to have a comprehensive safety audit without needing OSHA on-site? Well, how does a mock OSHA audit with a comprehensive, detailed report sound? If that sounds like what you're needing, the folks at Aero Safety can take care of you. Their mock OSHA audits include the whole 9 yards. We're talking administrative review of all safety training programs, written policies, procedures, and a physical walkthrough of your entire facility. To top it all off, the formal report they provide includes a detailed list of any deficiencies. Let's face it, we all have them. That includes pictures of those deficiencies and applicable recommended corrective actions to help you get on the road to compliance. If you'd like to discuss how a mock OSHA audit could help you improve your overall compliance and, more importantly, protect your workers, contact Aero Safety by visiting their website at aerosafetyus.com or by emailing them at info@aerosafetyus.com. Be sure to mention you heard it on the Safety Pro podcast, and you'll get 25% off your estimate. That's www.aerosafetyus.com. All right, welcome to the Safety Pro podcast. I'm Blaine Hoffmann, of course, and I'm talking with Phillip Russell. So, Phillip, we're going to be talking about what I enjoy talking about, but I'm also ignorant to an extent, which is why I talk to folks like you. And we've had you on before about some legal issues. So give us a little bit of background, who you're with, what you do, your background, and why I would choose you to talk about this topic.
All right, Blaine. Well, thanks again for having me back on the podcast. I enjoy following what you do, and really appreciate that you keep the focus on safety. And I know it's called the SafetyPro podcast, but whenever your delivery, I think is something that's very important and is needed in the industry and the profession, because safety is more important now than ever before.
Yeah.
So anyway, my background, I'm with a law firm of Ogletree Deakins. We're a national law firm, international law firm that focuses only on labor and employment law for businesses, only for the employer. My specialty area is occupational safety and health, OSHA. And I've been practicing now for almost 30 years, handled over 200 OSHA fatality inspections, hundreds of other kinds, and been recognized by, or I've been recognized by a lot of all those lawyer review agencies that all say, hey, he's done a pretty good job. So got a lot of those. But, if you go to ogletree.com or just type in my name, you'll find all the credentials. But as I said to an OSHA compliance officer yesterday, this ain't my first rodeo. We've handled quite a few of these, so he needed a little help, and we're happy to help him. So,
and we were talking just before we started recording, how I enjoy your LinkedIn posts, not to disparage anybody else, but the reason why I follow yours and always look forward to them is, like me, I'm interested in, like, what does this mean? Like, somebody will share, oh, hey, this decision was released, and that's it. It'll be a link. And I'm like, wait, yeah, but did you read it? Did you have an opinion on it? How does it impact you and what you do and your business, or what's your view on it? Let's talk about it. Like, anybody can share something. I find most of that stuff myself anyway. Like, I know when OSHA's coming out with something new. If you're a safety professional, you don't know OSHA's coming out with something or haven't heard about it, then you're probably not doing your job. The question is, you know, can we have a discussion like we're about to have? And I do want to set the stage a little bit. For anybody in podcast land, you're listening to this, you can see the full video over at the Safety Pro Podcast Community site. The link is in the show notes. There is no affiliation outside of just social networking, connecting with Phillip. There's no association or affiliation with Ogletree Deakins and the Safety Pro Podcast. They're not paying for this, any of that stuff.
Wait, I don't get to bill you for this, Blaine? Come on.
I was going the other way, but yeah, okay. And also, always talk to your attorney. And I know Phillip would have probably a better boilerplate for that. This is a discussion that we're going to have to hopefully shed some light on some things and to get you thinking about the impact that some of these topics might have on you and your business as well. So let's get into this topic, which is the Supreme Court's been on a roll lately, and the two cases that we've kind of combined for this discussion are really interesting. And so one is, has to do with Chevron. Is it the Chevron doctrine? Is that
Chevron?
Is that what it is?
It's called Chevron Deference.
Deference. And then another one, which was in my words only, an outright challenge to OSHA's authority. Let's talk about those two and what they mean for us in as far as workplace safety and health goes.
Well, let's jump right into it. And what you just said a moment ago, though, Blaine, I appreciate the comment on it.
Yeah.
I don't think that I think that lawyers can be their best for clients if they can take a very complicated system and try to make it as simple as possible. And I'm grateful for the gift of being able to do that sort of thing, because not all lawyers can. I come from small family business, and I think I've always just looked at ways in which I would talk to my family about a legal issue and make it something that they can take action on, and that's something they can understand. So I appreciate that. So We're going to try and do that today with some SCOTUS decisions, because sometimes that's where it gets to be a little challenging, is getting into some Supreme Court precedents. And we're going to talk about things like the Constitution and the separation of powers and delegation of authority from the legislative branch to the executive branch. That's what these cases are all about. But ultimately, for safety professionals, it comes down to the question of, what authority does OSHA have to regulate anything? And that has been called into question, And there has been litigation that's been going on that percolated its way up through the courts and made its way to the Supreme Court recently. That case is all states refractory contractors. And in the days of Google, if you just type in that name, you'll find the decision I'm talking about. And what it was essentially, it wasn't a full decision like Loper Bright on Chevron Deference, which we'll get to. This was a denial of review. And it's called certiorari. So what happens when a party wants the Supreme Court to review certain kinds of cases? They file a petition for a writ of certiorari. It was denied in this case. And the issue that was coming up before the court was OSHA's authority, its initial authority in the OSHA Act in 1970, was it too broad? Was it not defined clearly enough? Was it an improper delegation of legislative authority from Congress to the executive branch in the entire creation of OSHA? So this is going back to origin story stuff, Blaine, and calling into question whether or not Congress did it right in the first place. That's what that case is about.
Sure. So let's talk about a couple of aspects of this so that we all kind of are on the same page, anybody watching or listening. And so when we say Congress delegated too much, what is, according to the law, the Constitution, what can and can't, like, is there a line, like how much is too much and how much is not too much? Like, where is that? Why they were trying to get a decision out of the Supreme Court? What does that mean, delegate?
Exactly. So let's talk about it. Let's start first with the Constitution. You got to go to Article 1, Section 1. And it says that the Constitution vests, quote, all legislative powers herein granted in a Congress of the United States, close quote. And that's what Justice Thomas, he actually filed a dissent. He thought the court should have taken up review of this case when it decided not to. And these are the points I'm going to be making today are really from Justice Thomas's dissent, because he highlights the arguments that have been made below. And he also makes the point that there are at least 5 justices that have concerns about the authority that was granted to OSHA. So when you start with Article 1, Section 1, the Constitution says separation of powers concept here. All laws should be made by Congress.
Okay.
Right? The legislative powers. Now, think Schoolhouse Rock, Blaine. Let's make it real simple. I'm just a bill. Yes, I'm only a bill, and I'm sitting here on Capitol Hill, not in some bureaucratic agency in an office building down the street. Capitol Hill. So that's where it should be. That's where the power lies. Now, over the centuries and decades, there have been occasions in which Congress created an agency, many agencies, but those agencies don't report to Congress. They report to the executive. That's the president. And so when these agencies are created, it is the president's duty through appointments, et cetera, down the hierarchy to run these agencies. So in 1970, Congress created OSHA. And at the same time, by the way, they created the Review Commission, but that's probably a subject for another podcast. We'll dive deep into that some other time.
That'd be
because
good.
There are some issues related to review of that. So we'll set that one aside. But here's what Congress said in 1970. They had, and this was in the Act, it's Section 652(8) and 655(b) of the OSHA Act. It's 29 United States Code for anybody who wants to Google it. But here's the issue that Thomas has, is that the statute gave OSHA all the powers it needs to, quote, reasonably necessary, that Congress gave OSHA the power to enact and enforce any workplace safety standard that it deems, quote, here's the key, reasonably necessary or appropriate, close quote. That's it. And Thomas's issue is, wait a minute, let's go back to Article 1, Section 1. Congress has legislative authority, but that is, reasonably necessary or appropriate is so broad and so ill-defined that it creates a runaway agency. It creates an agency that does more than perhaps what even Congress intended. So over the years, and this takes us to the next step of the analysis, over the years, the Supreme Court has created what they call or they've allowed this delegation of authority. Because remember, the Supreme Court reviews. So Congress creates laws, the executive branch executes and enforces the laws. and we have judicial review is vested with the Supreme Court and the courts that all flow up to the Supreme Court. Article 3 courts, we call them. So, but under the precedent, so a delegation of authority at the Supreme Court is constitutional as long as it sets out a, quote, intelligible principle to guide the agency's exercise of authority. Well, is it really an intelligible principle to say reasonably necessary or appropriate? That's the problem. It's just too broad. Now, what I thought was fun and interesting is, Justice Thomas, whether you agree with him or not, he, I think, raises points that should be considered, especially considering that there are at least 5 justices that may eventually agree with him, 4 others anyway, is he makes this point. He said, what if the Internal Revenue Service, what if the Internal Revenue Code started off with the IRS gets to levy taxes that are reasonably necessary or appropriate? Would we stand for that?
Yeah, no.
Probably not.
So
that's the problem.
That comparison is important because you don't. So let's look at other there you go. Look at other agencies and where their limitations are, what they don't have. And so I was going to ask, what reasonable and necessary to who? The agency?
That's the problem.
Yeah.
That's the problem.
And then go back to your point of who are the heads, how are the heads of these agencies appointed? And we all know that personnel is policy. I don't care who you are or what side of what fence you happen to be on, or it doesn't matter. Personnel is policy. So when you appoint somebody to run an agency, there is an expectation that you uphold a certain approach, or there's some expectations, right? So, that can happen. You could have this vacillation from administration to administration. Let's say every 4 years we flip sides on administrations consistently. Let's say the business hates this uncertainty. We love predictability, right? We love things that we can plan for, these are the parameters. Okay, let's build up systems, processes to operate within these parameters, and then we can predict that. It's predictable. So this could create just chaos, right? If you could have that much power to make changes. For example, that's how you ended up with the administration. Not picking on this particular case. This is just the most recent one that comes to mind for me. Speaking for myself, this is how you could have the administration instruct OSHA to come up with a vaccine mandate during COVID.
Exactly.
And it was wait a minute, how is the administration allowed to do that? Right.
Well,
And of course, we know what happened with that.
Exactly, and that went down as it should have, 6-3. I mean, should have been 9-0 in my view, if you're following. But here, let me draw a distinction here too, Blaine. And some folks that are listening to the podcast might, if you're a court watcher, and maybe there are a few dorks out there like me. What's interesting is there is a difference in the court, and a lot of people like to say it's Republican versus Democrat, or who appointed which justice. The split is more fundamental than that. And actually, I think those labels don't serve well if you're really a court watcher. What you really should be looking at is those justices that follow the original meaning in the Constitution, textualists, folks that have their careers, that follow the jurisprudence of the document says what it says, and we're not reading in between the lines. We're not creating something from nothing. That's typically the conservatives. Then the more progressive or liberal justices say, no, we have to look at this in the context of today. We have to look and see what this means. And so they're less interested in holding to the exact language in the Constitution. It's more of a constitutional principles, although the wording may not quite be there. Yeah. And full disclosure, I'm in the conservative side of things. I believe that the words say what they say, and if we want to change it, there's a process to change it and clarify it. So I fall in the first camp. So full disclosure there. And by the way, you mentioned my law firm earlier. I'll just qualify that. Nothing I say today is on behalf of my firm, and I'm not giving advice for legal advice for specific situations. There's your disclaimer.
There you
Let's
go.
get back to let's get back to the dissent, though. What I thought was interesting about this, Blaine, and something that really safety pros ought to be thinking about is here's what he went on to say. He went on to say that because that intelligible principle concept the court has used is itself not well defined, and reasonable and reasonably necessary appropriate is not well defined. He said, look, OSHA, and I'm going to read it again from it. The Occupational Safety and Health Act may be the broadest delegation of power to an administrative agency found in the United States Code. And he quotes an academic article from 2008. The article is entitled, from a law review, the Virginia Law Review, is entitled, "Is OSHA Unconstitutional?" And from that article, the quote is, "No other federal regulatory statute confers so much discretion on federal administrators, at least in any area with such broad scope."
Mm-hmm.
And so the point there is really what we're getting at here is OSHA's regulatory authority.
There you go.
What authority does OSHA have to regulate workplace safety and health as written in the OSHA Act? Now, that is not to say, Blaine, that Congress couldn't fix the problem.
Correct.
And that's really exactly. So Congress could come together and say, well, maybe we should have been more precise, but reasonably necessary or appropriate. Let's have somebody introduce a bill. He's going to walk up to Capitol Hill and he's going to sit there and wait while there's debate, just like Schoolhouse Rock.
Like the way it's supposed to be set up.
Correct. So
right.
Fix it. Have elected representatives take that language, throw it out, and be more specific about the regulatory authority you're conferring upon this agency.
Right.
Now, that's probably a pretty good segue to jump over to the Loper-Bright and talk about, Congress and delegation, what we talked about there. That's sort of a broad attack that may come up with OSHA. But next, we'll talk about Loper-Bright and deference. A little bit
right.
different, but similar
to transition though, real quick, because this is my take, and tell me where I'm way off on this, by all means, because I probably am, and it's a sort of it's the impression that I get about it. So it's not these challenges, everything on Twitter and everything else is just so ridiculous, or X or whatever it's called now, because nobody takes the time. Like I like to think that I try to do my diligence, right, and read and learn about things. Uh, somebody was talking about the Supreme Court decision, a different decision that was made recently, and they were asking me what I thought, and I said, well, do you have 20, 30 minutes? And they're like, what? And I'm like, oh, but if I gave it to you in 140 characters, you'd buy it. You would, that sums it. Not everything can be explained or summed up or understood in a platitude, in a bumper sticker, right? You have to learn about these things and read and take time. When it comes to the administrative power that agencies have, am I off base in thinking that agencies, and this will get us to the Loper case, agencies that were given this carte blanche, like, you're the experts, quote unquote, even though you're politically appointed heads, which are mostly, administrators, but you're technical experts. You run the environment. You come up with standards for the environment. You come up with standards for the workplace. You come up with standards for the roadway. This is what you do. We don't do this. We're just elected. I'm just a senator. I'm just a congressman. Like, you do it. And then we end up with, in this case, OSHA coming up with a de facto standard that didn't go through, it wasn't promulgated, right? It didn't go through that whole process. We used to joke it takes 15 years to promulgate a new standard because it has to go through this process. But no, now we have temporary emergency standards. We have national emphasis programs. We get that just seem to go on, and then pop up, this new standard pops up, and now it's out. And I'm like, wait a minute, where did this come from? Is this what we're kind of getting into now when we talk about this next case? Is that very specific activity of creating regulations within the agency?
Yeah, and just leaving behind all states refractory contractors, the one on OSHA's authority, stay
Mhm.
tuned on that.
Yeah.
That case is over because petition was denied, petition for review.
Now, wait a minute.
But
That doesn't mean Supreme Court didn't say this is settled. They just said,
correct,
"We're not gonna review this."
that's right. We're not going to review it right
It
now.
could come up in
So
another form. They could retool that, right, argument or that request. It could go through another process and still land on the court's doorstep, and they could choose to take it up at a later date, right?
exactly, and that's
Got
why what Justice Thomas finished off his dissent by saying that there are, and he gave he referenced the prior decisions. There are at least 5 justices right now that would be willing to take it up and to review. And again, does
So
that mean
why
those
didn't
are
they? Maybe that's important to cover. They just decided
now?
it didn't have
Yeah,
merit the way it was presented?
I wouldn't even say that. There are so
Oh
many reasons why the court may deny petition for cert, and they don't ever tell you why, or they rarely tell
oh,
you why.
gotcha. They didn't
So
okay. They didn't say why.
they didn't say why. He said why not, and he objected to. Wait a minute, I think we should have taken this case. And some of you
Gotcha.
have said similar things before.
Alright,
So
so stay tuned on that one. That would be groundbreaking, if
well,
they,
what it would do is, again, I mean, and a lot of folks lately, like you mentioned the 140 characters, and so the social media attacks. A lot of folks attack the court for a variety of reasons. And I get it; people have different views, but this really wasn't a power grab by the court on either of
right.
these cases. Well, first of
Yes.
all, I mean, the first one wasn't a case, but Loper Bright. It's not a power grab by the court. What it is the court saying that Congress, it's time to do a better job legislating.
Do your
And
job. Yes.
yeah, do
Yeah.
your job. And the excuse of, well, Congress is broken and they can't get along, they can't get stuff done. I could point you to many, many statutes in the last 10 years in which they did come together, reach some agreement, and get stuff done. So
Yes.
I don't buy that,
And by
and
the
by the
way,
way, I
our
don't want to destroy
framers wanted our framers, in my view, my humble opinion, wanted a certain amount of that friction, that gridlock. That's the point. Otherwise, you would
yes.
have one group just running roughshod across the country, in some way, right? So you need to have those checks and balances is what we call them, right?
Well, that's exactly what it is. And you need to, I don't believe that we should sacrifice the constitutional structure of separation of powers for convenience.
Right.
Many of our founders are quoted as saying, and I agree with them, that that democracy, our republic, is messy. It's designed that way. So
Yeah.
that goes to the question now that came up in Loper Bright, which is how much should a court defer to a federal agency's interpretation of its authority?
Okay.
So if there is a dispute as to a regulation, then what had happened under Chevron deference for the last 41 years, I think, and that was the case. It was EPA versus Chevron was the case
Mhm.
back in, I forget what year, but 41, 42 years ago. And as a lawyer, most of my 30 years, we've been living with this concept that courts were under Chevron to defer to an agency's reasonable interpretation of its own regulations.
Right.
So the agency was able to write the rule and interpret the rule and enforce the rule. Well, that's legislative, executive, and judicial power all in one agency. And that was the problem the court had with Loper Bright, and the reason why they not only curtailed it, they threw it out
Yeah,
and
altogether.
said all together,
Yeah.
and said basically, Chevron is overruled. And here's the quote from the decision: courts must exercise their independent judgment in deciding whether an agency has acted within its statutory authority as the APA requires. Now, the APA is another statute, that's the Administrative Procedures Act, that Congress had also passed, that says there's a certain way that you go about making regulations. You have to follow this process, government agencies. And if you do, then under Chevron, there was some deference. But here, there actually was no deference ever in the APA. And that's what the court points out here, is that, you have got to make sure that you do not give executive agencies the power to be the judge, jury, and executioner. That's the issue.
So
And
the
a little
result
bit of a court thing.
and the result of Chevron was that it was really hard for a company, and a business association, a group, any party really to bring a challenge to some regulatory overreach or what they felt was overreach or something like that, because the courts would always go default to, well, the agency's the one that decided. Like, they wouldn't even take it, would make it really hard. Is that correct? Am I on off base on that, or?
Yeah, no, you're close. I mean, it's look, the issue comes down to, and this is what one of the dissents pointed out or tried to argue in Loper Bright, was to say, wait a minute, we have to allow deference to agencies because of expertise, because they are experts in what they do. So,
Eh,
okay, true, but you know who are experts? You know who are the experts in interpreting words and applying them under the law? That would be
Judge,
judges.
yes.
Right. So that was the point that the majority made was, hey, wait a minute, dissent, I hear you, but this isn't about technical expertise. This is about the scope of authority granted to the agencies, the executive branch from the legislative branch, and was it appropriately given? And if it's unclear, the answer is not for the agency to redefine the term or fill in the blank. The answer is to go back to Congress and get clarification.
And is this how you get like the CDC getting into whether or not property owners can charge rent during a certain period of time during the pandemic, things like that? Like, there's
Similar,
some
similar
weird things I've never heard of come out of the last 5 years, 6 years or so, that were strange.
3.
Whether I agree with them or not, did they go
Yeah.
through the right process is the question.
Yeah, I'm going to say 3. I mean, it's been an interesting time to be sure. I mean, on average, the U.S. Chamber usually has 2 or 3 statutes a year or regulatory actions that they're challenging. Sorry, not statutes. I think they're at 19 right now. I think is some stat I heard. So this has definitely been an administration. Now, by the way, I'm not blaming just Democrats and not just President Biden and
No,
his administration.
right. I got plenty of
It's been
examples. Yeah.
Yeah, it's been across the board Republicans and Democrats. And that's what really the court was doing here. And again, it wasn't a power grab. It was really, I think the message of Loper Bright is Congress needs to do a better job of giving well-defined authority to agencies so that they can then create standards or regulations consistent with that statutory authority
Right.
that is not unclear so that a court would easily enforce it.
Okay.
And
Yeah.
so that really is the message, is be clear. And I'm going to use an example. Let's put this in terms of OSHA's proposed, actually, I should say OSHA's in effect standard for the walk around rule. So
Right.
you know what that is.
This is a great example. And this, I think, one of the reasons why I wanted to talk to you, it was the Loper case came out, and then I was immediately started thinking about the walk around rule.
Yeah. Well, why did you think about the walk around rule? What made you think about it?
Because how it came about, and what mainly what the not just the impact, but like some of the, if you read the walk around rule, the with the outside agents or representative, like just how that came about and
Well,
how they wrote that. How
and
did that
here's
get
where
in there?
exactly, and here's where it's in jeopardy. And the walk around rule itself is in jeopardy after Loper Bright. So the OSHA Act itself, going back to the statute, what Congress said whenever in 1970, one of the sections is 29 U.S.C. 657. That's section 657. It deals with inspections, investigations, and record keeping. And the section E deals with the walk around. And it doesn't use the word walk around, but it's the inspection of the workplace. We just call it the walk around, as everyone does.
Right.
But in that statute, it's not very long, but it several times refers to representative authorized by employees or an authorized employee representative. But some way or another, it puts the words authorized representative together. And for decades, that was understood to mean that employees had formed a labor union through the process set forth in the National Labor Relations Act. We have an entire body of labor law that's been around since the 30s and 40s about how employees come together and form a union, a labor union. There's a process that they go through. So it's always been understood that's what the reference was to. Well, OSHA took a look at it, and they tried this back in 2013, backed off, didn't try a proposed rule. They just
Yeah, I
took a
remember
letter.
that.
Yeah. So
Yeah.
now in 2023, they say, wait a minute, we're going to do a rule. We're going through rulemaking this time, and we believe that authorized representative is OSHA's decision. The compliance officer gets to decide, and that's what the walk-around rule says, is that the compliance officer gets to decide, and gave some criteria that are so general that it's hard to even understand. But I think that walk around rule is going to, I think, ultimately go down because of Loper Bright,
And
because
that
I
goes
don't
to
think a court.
deference. It was
Correct.
they had the deference, and so we're going to rely on that.
Right.
That
And
open door to
so
push. Okay.
OSHA would argue, if challenge if Chevron deference had still been in effect, and it's just a reasonable interpretation, OSHA would argue that it's reasonable for us to look at this statute and say, hey, wait a minute, Congress didn't specifically refer to the National Labor Relations Act, so therefore they must have intended to create another pathway for these, labor organizers and others, because it doesn't speak to just labor organizers. It could be any third party, but
Right.
non-employees on this job site, right? And
Yeah.
and that would be the argument. Now, I think that argument would fall short and would not be successful even under Chevron deference. But now that deference is gone, and the Supreme Court has said courts need to do your job, Congress, you need to do your job, and you don't just hand this to an agency and let them decide what their own regulations mean, then that means that this is going to go down, because I think a court at some point is going to look at this and say that authorized representative does have meaning in the law, and OSHA doesn't get to add a new meaning to it that's never been there. That's the impact, I think, for us.
Yeah, interesting. So getting back to Loper, in general, the the first case, the first review that was not taken up by the court. How do you see these two? Do you see Loper potentially setting the stage for another case, maybe, or to go in front of the court that does challenge the extent to which OSHA has authority over regulating workplace safety in this country?
Yeah, the chamber right now has a lawsuit that's already pending challenging the walk around rule.
Okay.
So all they will do is, the lawyers that are there, and I'm not directly involved in that case, but have some indirect contact to it, but no direct representation on that case. But I would expect, if they have not done it already, the lawyers there will be amending the pleadings in the case and motions to bring this issue up and say, hey, Judge, under Loper or Bright, you cannot defer to OSHA's interpretation, and this is not what Congress intended. Here's our arguments. And I think ultimately, I don't know, it's going to have to go from a trial. Right now, it's in a trial court. It'll have to go from a trial court up to the appeals court, and then I think it will go to the Supreme Court.
And these things are important for us to understand. um you know I support workplace safety and health. I mean, no, workers uh deserve to go to work and not have to worry about whether or not they're going to go home. I mean, our country has gone through a lot since our inception in this regard, from child labor, right, to just horrible working conditions and pay, and things like that. And the Industrial Revolution introduced uh, a whole series of mechanisms of injuries that we didn't have to face before in history, in our working history, really globally, if you think about it, when the Industrial Revolution came about. So I want to be clear. Like, for me, I'm a workplace safety and health professional. I've dedicated my entire working life for the almost 30 years now to keeping people safe. There's dignity in work. There's honor in earning a living and being productive. I love that in our country we have the freedom um, to just switch careers if we want to choose to work in for different companies, and the opportunities that we have. And I do believe ensuring the workplace, the safety conditions in the workplace is key to that, to the success of our country. That said, I also recognize that if we don't have this framework that just doesn't have to do with workplace safety and health. It has to do with our legal system. And it has to do with the separation of powers and delegation, all this stuff. If we didn't have any of that, I don't know where we would be. Well, I have an idea where we would be. I can point to other areas of the world, but uh,
Well, let me kind of kind of put a bow on this for you. I
yeah,
mean, I think Blaine, you're touching on some interesting things here. I want to be very clear about this. I think safety pros and certainly management side safety lawyers like myself, you focus on these things with it doesn't compromise your focus on safety.
right.
I am a safety lawyer for lots of reasons. I will tell you that, one of the things that personally impacts me, and I don't remember if I've shared this with you before, but I lost my mother in a workplace accident. So, and truth be told, I'm not an OSHA lawyer because of that, but it does impact how I approach this job. And, I've got a lot of friends at OSHA from Doug Parker all the way down to area offices. And I respect immensely the men and women that work for the agency and do what they
Right.
do. And there are a lot of true believers, and I agree with them on a lot of things. I really do. And one of the first thing that happens if you're my client, and this is how you get fired or don't get to be my client, is you first have to prove to me that you take safety seriously.
Yeah.
And if you do, then I'm a good fit to be your lawyer. If you don't take safety, and there are certain employers and industries that I am skeptical about
Yeah.
because I'm concerned about their focus on safety. So I don't work with companies that don't take it seriously. So having said that, why are we talking about, OSHA not having authority? Why are we talking about OSHA shouldn't get deference in these cases? Here's why. Because who decides the rules matter.
Yes.
And that's what these cases, you bring them together, that's what this is all about. Because we have to be able to pursue safety and health, safe and healthy workplaces in a way that is consistent with our laws of the land. And nothing I've said today would change. If Congress wanted to improve upon the OSHA Act, do it.
Yes.
And I
100%.
got a lot of
100%.
recommendations.
Oh yeah, me too.
Right.
Yeah,
So,
good ones too, in my opinion. But of course, but getting to your point with the Loper decision, that was brought by Loper was correct me if I'm wrong, an individual, a fisherman, ran
yeah, it was.
fishing, and it had to do with an environmental standard from the National Oceanic Agency, or NOAA, that came up with this requirement that fisheries had to have a monitor on their boat, simply to ensure that they were following the rules. Then they said, oh, by the way, the fisheries have to pay for the monitor to be on. So let's take this to the workplace safety example. Could you imagine if, well, OSHA's deference is, in order for us to really ensure, and OSHA hasn't said this, at least that I haven't heard, but if we want to really ensure workplace safety and we want to really make sure companies are following the law, which is the law in workplace safety, we want a compliance officer at every work site and every company site. And we want the companies to pay for it. And that's how we're going to do it. That is what deference to the agency got us. And
That is an interesting perspective, Blaine, that I haven't thought about. But you're right. What if that had been a workplace safety scenario involving OSHA as opposed to fishing boats and a monitor? Good point there. But that goes back to what I said a moment ago, Blaine, is that you can both be an unabashed safety advocate, as you and I both are, but still want it done in a way consistent with the laws of the land.
Yeah.
And start with a constitution. Then when you look at this Congress's act through a statute, then you look at a regulation from an agency. And if they all fit nice and neat together, that's how it should be done. Now, I'm going to touch upon another issue, which, based on our chat, I think you'll enjoy too, is it really comes down to what you define as the word freedom. Yeah. And I've discovered this over my decades of being a management side, employer side lawyer, is some folks define freedom different than I do. I define freedom and what I understand it to mean from the law. And again, this isn't my feelings. I hate that word, but I mean, this is my understanding of the law and our jurisprudence, and having gone to law school, is that freedom is freedom from tyranny, which means freedom from government overreach. But I've also learned over the years that there are some other folks that see it differently, and they view freedom as freedom from pain. And in this case, you might say freedom from workplace dangers or hazards. And therefore, because the government is here to provide protection, I would allow for more government intervention in the workplace for safety. And that's a view you have to acknowledge and understand as a safety pro, that's part of right now the folks in charge of regulations. That's their view. And it doesn't move. It tends to go back Republican and Democrat, first scenario, second scenario, but it's not always that way.
Yeah.
So it really is a matter. And so my view is, of course, I think that there are tremendous safety pros out there and amazing companies out there that even if the OSHA Act was never written and OSHA didn't exist, would still have a safe workplace. But I also acknowledge, Blaine, I want to be clear about this, I also acknowledge that there's a segment of employers out there that really need the hammer of government.
Yes.
And so I don't know. I'm not the king of the world here, but if I were, rewriting the OSHA Act, I might do something along the lines of make it, focus on compliance, but maybe have a bigger hammer on the backside. Who knows?
Yeah.
Total speculation here as to what
I
we
do. Yeah, and I think and to piggyback, I guess I should say, piggyback on your definition of freedom again. I mean, just my personal view of life in general. And to me, freedom instead of saying what I believe it means, I'm gonna maybe talk about what I believe it doesn't mean. And to me, freedom in the context of our system of government and in the United States doesn't mean anarchy. It doesn't mean I get to do whatever I want, whenever I want, however I want. Freedom, you could look at the religious view. You could look at like other examples of a framework and a structure by which we live by and are governed by, but we still have freedom. It's just, if you think about it, we have moral standards, right? We have natural law, right? So I do believe there's a framework that will help do several things. Ensure our freedom and liberties as defined by nature, by our creator, and then freedom from a specific thing. And you said tyranny of government, but then also, others, right? Like the reason why we have laws, like I can't just go and take your property. I mean, I could, but there's a consequence to that. And because, you're involved now. And so when I look at the workplace, I think, okay, we've got to have this sort of, I don't want to use the word contract, but I'm going to use scare quotes around that word. We have to have this agreement like, hey, I'm going to come and do something for you and you're going to give me something in return. Today we will call that money, right? A paycheck. And part of that arrangement is that, you shouldn't be able to do something to me physically, like knowingly or unknowingly. We got to have some sort of arrangement and we have to have an agreement. I do think there's definitely a place for regulation and government in our lives, especially under like example of contracts and things like that, contract law. But yeah, it has. But the reason why it works is because we have these checks and balances. We have this friction that is built into the system. People call it gridlock. I don't look down too much on gridlock, to be honest with you. Hey, look, if they're fighting in Washington over whether to raise taxes or lower taxes, and then the result of that back and forth is 5 years, they do nothing to my taxes. Well, then at least I know nothing's happening to my, you know what I mean? At least I know what I have. That's good, I think. And I think that we definitely need to get back to, let's have a discussion about these things and let's have differing parties have a voice and have a say in what the impact would be. And the other thing is with deference is I could ask different people how they feel. I know you didn't like that word, how they feel about a particular injury trend in industry. And some would say one is too many. And it's like, well, yeah, but we're talking about policy. We're talking about people. We're talking about a country of 350 plus million people. I don't know how many are working right now, but Zero is not realistic. And I'm not saying you accept any of them, but I also understand public policy can't be based on zero, can't be aimed at zero. Just like public health, right? During COVID, everyone was talking about when we have no infections, that's when we'll relieve these. And I'm like, well, that's never going to happen. You can't run public policy on a goal of zero. It has to be, you're talking about the public. It has to be reasonable, right? And now they have to hash that out. But when you take that hashing of it out of the equation, in my opinion, you're one step closer to, you would say, some might say tyranny, and some might say, an iron fist, or you would have things like what we were talking about come out. In my opinion, this is just my thought. And it's not a political stance. It's just, I'm just looking at it. What I like to believe is pragmatic. You would end up with this. Yes, this agency gets to do whatever they want, and they're almost unanswerable, right?
Well, look, I'll go back and I'm going to reach back and a little bit here as well as we did earlier with some history, but I'm going to reach back to President Reagan, and he was famous or infamous, if you want to call it that, if you have a different view. But his statement that the 9 most dangerous words in the English language are, "I'm from the government and I'm here to help."
Yeah.
And actually, if I were in my office right now, you'd see that on my wall behind me. Now, let's just be clear about that, Blaine. That doesn't mean that Reagan didn't believe in government. He did,
Right.
But he believed in that government with the balance, and that's what we're talking about today: is the balance, is getting that balance back. So that was a political platitude at the time. But Reagan was also, whenever he delivered those comments, usually was talking about a government program of some kind. So let's put it in the right context. But I think it says it delivers the message quite well that balance is needed. That government is not the only solution to your problem. And I will again say this: I do not believe that companies are only safe for one reason, and that is government regulation. I think there are many reasons why companies have a safe place for workers to be. I'm not saying that OSHA is not necessary, but perhaps balance. And I think that's what we see from these two decisions is looking for better balance, better clarity from Congress as to what OSHA can and can't do.
And I believe that having a standard, whether it is an OSHA standard or regulation to follow, or an international standard or a business standard across many companies or across an industry, I think that's wholly good for businesses, right? If your competition is at least following the same standards, like for quality or maybe for hiring or pay and benefits, like it kind of levels the playing field a little bit. We know now the level of entry we're going to be making into this industry if we want to start a business. We know the rules, we have the playbook, and it goes back to my comment of businesses don't like uncertainty. Like there's no way you can operate from quarter to quarter if things could just vacillate wildly with regulations.
Right.
It's crazy. So I do like this predictability. And in safety, I appreciate that as well, that we have some standards that we can follow, that we can look to. And then my experience, I don't know if your experience is like this. Most companies I've dealt with, certainly the companies I've worked with, there have been a couple rough ones early on in my career. When I interned somewhere, there was an OSHA trailer out front in their parking lot with 3 full-time compliance officers on site at that location. Now, I don't know. I don't think they had to pay for them though, but because of their record. Now, that's another one. Is they had contractors coming into their facility. The contractor fatalities were through the roof. It was a fatality a year for almost 9 years straight on average at this steel mill. Not the steel mill company itself, but the contractors they would hire to come and do turnaround work and shutdowns and do maintenance and repairs, would come in and not have a lockout tagout program or fall protection. So, but the steel mill was getting hammered by OSHA, and they parked a trailer right there on their property. And I thought it was interesting that OSHA could do that. That like every day. They're there full time at your place. Um, so look, I
Well,
think,
let me be
yeah,
clear about that. If they were to try that with one of my clients right now, they'd have a big fight on their hands. So I'm
yeah,
not
you
sure
might
that
know who
all
I'm
would
talking
make.
about. This was in the 90s. Yeah,
Yeah,
all
no,
through the
I don't want
90s.
to
But
draw too much of a parallel from that case to now, but I would not be a fan of that approach. But anyway,
yeah, but Loper, what it does, I think, in the end, to wrap this up, is it it's like, okay, do your job, Congress, right? Do your job.
that's right.
Don't pass. I mean, what else are they doing if they're not doing their job? Don't pass this off to an agency. This isn't their job. There are checks and balances. There are limitations, right?
That's it. That's
That's
the
it.
whole idea. I mean, who decides the rules that we live under matters.
Yeah.
And these two decisions from the again, I know the all states refractory really wasn't a decision; it was just an
Right.
indication of what may to come. But when you look at Loper Bright, the message here is that who decides matters, and Congress needs to do a better job. And when I often have heard this objection the last few weeks is, well, Congress can't, Congress isn't experts, judges aren't experts. We really need the experts in the agencies. Wait a minute. Congress has hearings all the time and they call witnesses all the time. They're
Right.
your experts. You can do this. You can write. And I'm not asking. I don't think that the law and our Constitution would require uh, Congress to write a fall protection standard.
Right.
But you
Exactly.
need to be right. You need to be clear about the bookends of authority, the scope of authority that OSHA has within which to write a standard for fall protection. That's what this is about.
Yeah. Indeed. I got you. Yeah, that's great. All right. Awesome. Hey, thanks for breaking this down and helping us understand. I know we talked about a lot today, but it was definitely in the context of what we all would agree of this framework. Like when we start eroding the framework, I mean, we have no idea what's coming. So, um, awesome. And where can folks find more about you? You have a podcast too, by the way. Talk about that.
Yeah, dude. Through my firm, so I don't hide. I'm a professional service provider, so I'm easy to find. You can find just doing a Google search. Phillip Russell and Ogletree is my firm. Ogletree. LinkedIn, I'm all over LinkedIn, as you said. I think around 10,500 followers, something like that, and mostly safety pros. So I expect that some of our audience today have probably seen some of my stuff on LinkedIn. I post usually 2 or 3 days a week about
Hmm.
something related to OSHA. And sometimes it's regulatory, sometimes it's just what I'm doing during an inspection or a citation I'm looking at or a litigation we've got against the government on the citation. So I try to cover a lot of things in a very practical approach. The podcast is called Dirty Steel Toe Boots. And
Yep.
it's also through my firm, but I think you can find it if you do. I Google search it myself, and you do search for my name and Dirty Steel Toe Boots. You should find the episodes. But I'm always happy to be here with you, Blaine. Enjoy the
Yep.
conversation. Some people might think, wow, why are you guys getting into all this politics and political things? Well, you know what? I think as a lawyer that represents companies and as safety pros, I think it's important to understand these things. And I also understand that some members of your audience may not agree with me on these things, and that's
Yeah.
okay too.
Yeah.
One of the things we've lost in this country is the ability to disagree. So hopefully, if folks disagree, share your thoughts. Let's have a conversation about it. And
Yes, that
I
gridlock. We
think
need that gridlock. I don't wanna
that.
talk to everybody that thinks like me, I mean, personally. Um,
Mhm.
but, oddly enough, though, I think, correct me if I'm wrong, isn't the Greek politic, the word politics comes from a Greek word, it means social. I
Oh,
mean,
does it? Huh, I
yeah,
never looked
yeah.
it up.
So I don't think we were talking about politics. I think we were talking about our society. I think we were just talking about the country and the framework that we operate in, that we live under. And that was the context. And that, yeah, there are folks that agree and don't agree, like that don't like the framework. But I mean, that's what it is. If there's a way to change it, but nobody's changing it, they're looking for ways around it, and that's where I think we have problems, because that kind of uncertainty isn't that nobody can possibly operate a business under that kind of uncertainty, let alone
Well,
live as a citizen.
Well, here's my closing argument, and I'll use that word. Here's my closing argument for this conversation. None of this should take your eye off the ball when it comes to safety.
Yes.
Nothing. So every one of our safety pros listening today, focus on keeping the men and women that are working at your job sites, in your facilities, whether it's inside or outside, keep them safe. Focus on that. Do your job. These legal issues will sort themselves out in time, but I think it's important to understand the context in which you all do your jobs. And so, Blaine, thank you for what you do. I know that what you do with this podcast is something you care a lot about. You're passionate about it, and I support anybody advocating for better safety for workers.
100%. And I used to tell my clients all the time, you don't want OSHA knocking on your door. Do the work that won't give them a reason to. That's it.
Indeed.
Don't give them a reason.
Blaine.
All right. Thanks. We'll talk to you soon.
All right, there you go. Once again, I thought it was a very productive conversation, and we uncovered a lot of information, I think anyway, I know I did, about how something like that Supreme Court decision could potentially, down the road, we don't know yet, but could potentially influence or impact the OSHA rulemaking process. I thought it was interesting. I want to know what you think. Once again, head on over to the SafetyPro Podcast Community site, participate in the conversation over there, and I will talk to you on the next SafetyPro Podcast.